Awesome.
as we'll find out through this
Of course.
presentation.
Well, and like the last one, I definitely want to make sure that this is a discussion. We might need to get a little more participation per person since we're a little smaller right now. But these are meant to stoke conversation. I'm here to facilitate the conversation more than anything else. And of course, I do have the background and everything so that we can see what the law is and sort of go within the confines of that. So we are going to start here if the computer moves forward. Uh-oh. Well, that works. With a quote. And the quote is, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." That is Benjamin Franklin, who I also let off with last week. Any thoughts on the quote?
I think it was not liberty nor safety at the end. I think it was just deserve neither. I mean,
I've seen it both ways,
Yeah.
but any other thoughts on it? Especially in the context of, we're talking student privacy. I know that, yes, Ted?
I have a question. Is it
Sure.
quoted often?
It's quoted very often. This has come up a lot.
Yeah.
This has come up a lot since September 11th.
yeah.
You see it a lot in response to the Patriot Act and some of the invasions on our civil liberties and personal privacy, not necessarily in the school context, but in your homes, on your phones, computers, email. Just for full disclosure, I'm going to give you a little background on the quote. When he says essential liberty, he did not mean civil liberties. This was actually an issue when he was in the Pennsylvania General Assembly. Before the Revolution, he was writing to the Crown and to the Penns. The Penn family governed Pennsylvania. The issue was the Pennsylvania General Assembly, the colonial elected officials, wanted to tax the Penn family to raise money for defenses. And the Penn family balked at that. The Crown said they didn't have to. The Penn family offered to pay them one time to do the defenses, but only if the General Assembly would say that they would not collect taxes on the Penns, that they didn't have that power. So when he's talking about essential liberty, he's actually talking about the power to tax the Penn family. And more broadly, you could say self-governance or sovereignty, but it's actually not civil liberties, even though today, we, as Ted, I think, was pointing out, we quote it all the time in the context of civil liberties. And that is why I put it here, was in the context of civil liberties, of course. So with that background, any other thoughts on it, maybe as it relates to student rights, or what do you think? I mean, do you generally agree with that? Do you agree that liberty is that important that we shouldn't be sacrificing it for safety?
There was something I was watching recently. It was a TED Talk where the guy was describing his book, Dangerous Things You Should Let Your Kid Do. And it was just sort of about like letting kids explore, and they're not really dangerous things. They were like licking a 12-volt battery.
Who hasn't done that?
Yeah, that was like one of his questions. The audience is raising their hands.
Well, yeah, and I think that's interesting, and especially in the context of, I guess we probably all have a balance, right? Maybe we think that it's okay to have to go through a metal detector at the airport. Maybe we think a more invasive search isn't worth it. People do strike a balance, and clearly, I think even if you look at the history of Benjamin Franklin, well, he signed on to the Declaration of Independence and the Constitution. He created a federal government, which did sacrifice some liberty to the federal power. So I think we all strike a balance, even when we're looking at a quote like that.
But I think, Ben, that safety is a little bound, as is probably liberty, by time and culture.
Mm-hmm.
Because what people think about in terms of safety is colored by the media.
That's a great point.
There's a bit of mass hysteria in our age, I think, that the media fosters, the 24-hour news cycle about what it is to be safe. And so you think about that context of Benjamin Franklin's time, and it's quite different. And we even see different styles of parenting now than we saw when I was growing up
Very
as a
true.
baby boomer. That parents helicopter a lot more than mine. So I had the freedom to lick a 9-volt battery. My parents didn't care, but that might not happen in this day and age. So it's a really interesting quote, but I think it has to be put into context.
I agree.
There's a greater point in this discussion about balance that somebody who's really prominent in discussions about security and safety by the guy by the name of Bruce Schneier, and he is known for, like, after the 9/11 attacks, criticizing what he calls security theater at airports where the guns weren't really loaded. And his point that he makes again and again and again is that people are basically misassessing, if that's a word, the risk that is posed to them. And so he's on Vox recently. If you type in Bruce Schneier, even if you misspell his name, it'll probably pull up on Vox. He says that, you know, if I have one point to be taken away from all this, it's that your brain is not processing risk appropriately, because we you know, evolved in hunter-gatherer societies, and that's how we have been adapted to assess risk and just sort of making knee-jerk decisions, and there's a tiger behind that bush. And so it's more survivalist to believe that there's a threat when there isn't, than it is to believe that there isn't a threat when there is.
Yeah, and I think that's a great point, and the points about media as well that Susan made, because you know, the context does change all the time, and we you know, anytime, if you've taken a statistics class that talks about risk at all, they talk about just how people react to certain risks. Look at Ebola. How many people died in the United States from Ebola? Did they die in the States? I don't even know if it was in the States. But and you know, that was national news for months. So it is, you know, something that we do. And to put it in the context then back to searches, would we have submitted to the Patriot Act before 9/11?
The last time you were here, you made it very clear that we're talking about students' rights in the context of high school, college. You know, there's a vast difference. And are we going to keep that?
We are going to keep focused on high schools. We are going to talk about FERPA, which also applies to that's the federal the Family Educational and Privacy Rights Act, FERPA, which does apply to college students, but we're focusing on high school again because that's where a lot of the case law on this sits, especially as we get into searches.
There is another thing. It isn't just where the federal law is. We can talk about law, but there are actual factual situations.
Exactly.
Columbine or whatever.
Yeah, exactly.
So, well, we'll get into it.
Yeah,
A lot of
absolutely.
things have happened since that event.
Oh yeah. Let's see here. So here's a quick overview. We're going to be going over the background. We're going to focus mostly on the Fourth Amendment. And I do want to make a quick point here. The Fourth Amendment covers searches. What that actually largely refers to is reasonable expectation of privacy. That's a big part of the analysis under the Fourth. You also have a right to privacy under the 14th Amendment. That's the Due Process Clause. It says the states can't deny liberty without due process of law. Cases like Griswold v. Connecticut, which ensured access to birth control, Roe v. Wade, which of course ensured the right to abortion, and Lawrence v. Texas, which struck down sodomy laws, are all decided, at least in relation to the 14th Amendment and a right to privacy. A right to privacy is not explicitly in the Constitution. What they say is it's a penumbra of the other rights, and that even applies to the Fourth Amendment to some extent, though the Fourth Amendment, as you'll see, does talk directly about search and seizure. So we will go over searches and what's reasonable, and then we will get into privacy at school in that context. We will talk about whether students have full privacy rights. So 2 weeks ago we talked about the First Amendment and free speech, whether students had full free speech rights in schools. We'll make a similar comparison today. We are going to talk about suspicion list searches and suspicion-based searches. There's a different context for each one. I gave a little bit away for my later questions. And then we'll get into student data and especially FERPA. It's really sort of an overarching law on a lot of student data questions and student privacy rights, in terms of data privacy, that is. Okay, so the Fourth Amendment. The Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. As you can tell, we're focusing on the first half of that, the search half. Warrants, they're obviously important. You're typically not going to be dealing with that in the school context, and it does have its own line of cases, really. So we're focusing on the first half of that. It is incorporated to the states through actually what I just talked about, the Due Process Clause of the 14th Amendment. And I say that as a technical note, but it's also an interesting point for this because it comes from Mapp v. Ohio, which was a case in 1961. Another part of that applied what's called the exclusionary rule to the states. And what that means is if the government does conduct an illegal search and gets evidence from it, that evidence will be excluded at trial. So you can't be convicted based on evidence that the government illegally obtained. So with that in mind, we're going to, actually I think this is a little out of order, but we're going to talk about what is unreasonable outside of school and how does that connect to the school environment. And then we're going to talk about whether the Fourth Amendment does and should apply in the school context. So before I give anything too much away with this first case, CAC v. United States, let me give you a little background. So this was a guy who the police suspected was involved in illegal gambling. And he went to make a phone call at a phone booth, closed the door, and he spoke over the phone about some numbers, about bets that had been made. What he didn't know was that the FBI had put a listening device on the outside of this phone booth. They heard everything he said, and they were able to, I believe the lower court convicted him. Went up to the Supreme Court, and they had to decide, did he have a right to privacy in that phone booth? And if so, did the government have a legal reason that they could still listen in without a warrant? They did not have a warrant for that. What do you think? Can the government do that? No? Why not?
I mean, technically that's like you're going somewhere for privacy. Phone calls are considered private even though it's through a public phone. You are paying for that public phone for privacy.
It's true. What if there weren't a phone booth? What if it were just, like one of those little sort of where they have the thing on each side, but you're not inside a phone booth? Do you think they could listen then?
No, because there's still privacy walls there, sort of.
Yeah, but someone could stand behind you and hear it.
That's hearsay.
Well, no, I mean they could still record. They can hear what you say, and if it's the government, they can record that, and then it would be evidence because it's not going to be hearsay if they have it on tape.
It's the expectation of privacy that is in question.
There you go. Expectation of privacy. All right. So let's jump ahead to the next slide. And this was some really interesting language. I believe it was Justice Warren that wrote the opinion. Not positive. For the Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection. But what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. This is really important. Prior to this case, the expectation was that you had privacy in your own home, and the place mattered. But now we're saying it's not the place, it's the person. It's your expectation of privacy. So what is a reasonable expectation of privacy? Any thoughts on that?
I can throw a monkey wrench into it.
Sure. Yeah, go ahead.
There is a lot of data that's being collected now on students, and for various reasons.
Uh-huh.
And so, in fact, the Federal Education Rights and Privacy Act was intended to create a divide between the information that is granted to schools so that you don't have, say, military recruiters going in and collecting,
Well, now there's an exception that they do allow that. They have to give the information.
Yeah,
to
yeah.
But
yeah, so the monkey wrench is really centralization versus decentralization of student information and data.
I can kind of see that. Tim?
Now you look at the First Amendment, nowhere is the word privacy used. So now you're talking about a concept of privacy, which is the judicial concept.
It is.
in the
It
cases.
is.
And how do they derive that privacy as coming out of the,
Well, I think, 2 points. So they talk about the penumbra of privacy, that it is this extra constitutional protection that's derived. It's essentially that they don't believe that the Fourth Amendment would stand on its own if there weren't some form of privacy protection in there. And I do think that they're careful. You do see right to privacy, but they really are careful to couch in the language of an expectation. And I think that's really important, and that's why I pushed back on the phone booth question was, if I'm having a conversation with Ted, maybe there's a difference, if the door's closed versus if the door is open. If they can put a listening device on the window and they otherwise wouldn't be able to hear in, well, that's one thing. If I have the door open and they can just hear out there, that's another. I don't have an expectation of privacy if other people normally would be able to listen to it.
But it's one thing if it's a person listening, it's another thing if it's a hidden device that you don't know about. That seems a little.
It is. They do try to make the distinction in the cases a lot of the time. And this falls, they talk about this in a number of contexts. They'll sometimes talk about plain sight doctrine and open field. So that's if you have property and there's a line of sight to activity on your property. Well, could a person normally see that, or do you need really specialized equipment to see it? They've struck down, for instance, infrared cameras being used by the police without a warrant, to see what's going on in a house. But a pair of binoculars, yeah, that's probably okay.
See, in journalism, we focus in on public eye
Mhm.
and try and teach students, if you're walking down the street and there are a bunch of young ladies sunbathing,
Mhm.
there's going to be a lecherous guy who's going to go click, click, click. It's fine, public eye, you can see it.
Yeah.
But, if there's a fence and you go over to your neighbor's house, it's no longer a public, second floor, it's no longer a public.
Yep. If you need a ladder or something.
Right. Which kind of goes along here, not a conversation, but, it's people, not places.
Do you have the
There have been more than a few cases where people have had their photos taken.
Mhm.
All right, people, not places. Well, if they go to a carnival, there was a case in Georgia. The woman came out of a fun house and they had the blower to blew her dress up.
Yeah.
Okay.
Yeah.
And the court ruled in favor of the woman. So it ruled in favor of the person, not the place.
I've seen that go the other direction too, because that's a really tough one.
Yeah.
They actually had an issue with that in Boston. There were sort of peeping toms taking creepy pictures on the subway, and essentially what they said was, you expose it to the public, it's public view. So you can see that going both ways, and
Just how
that's part of the
creepy were
problem.
these pictures?
Yeah. Huh?
Just how creepy were these pictures? Were they like across the aisle on the subway?
Yeah,
or-
yeah, and like trying to look up women's skirts and things like that. And
Okay.
it's so you can say it like reasonable expectation of privacy. It is squishy. We talk a lot about this, and again, getting back to the current context, I got a question. If you get on the phone right now, if you even say the word bomb, do you think someone's listening to your call?
Mhm.
I think
So if we all think someone's listening to our call, do we have a reasonable expectation of privacy? If we think someone's already listening in? I don't know. And does that erode it? Because 20 years ago, you're talking pre-9/11, you probably wouldn't have expected them to listen into your call.
It's funny when you say, like, the public's perception of an expectation of privacy, because when the phone was first invented, they didn't keep it in
Mhm.
their house. They kept it out on the porch.
And there are
And
some
there
really...
were like party lines, and you could
I'm
listen
gonna-
to each other's lines.
And I'm going to pull this a little
Several
bit back
Madcap
from...
comedies about that.
I'm going to pull this a little bit back from technology because I get into it more later, and there's some interesting quotes on it. But it's intertwined with that question of what is a reasonable expectation of privacy. It's such a squishy thing, and you're supposed to be looking at the reasonable person and sort of, where is that reasonable person placed? One issue, and I know Miriam got into this in the fall in her discussion series. Well, what if if you're renting an apartment, a small, one-bedroom apartment? Well, your reasonable expectation of privacy, you don't have as much privacy as someone who's got a mansion on 3 acres of land. I mean, that's a big deal. It's a huge socioeconomic difference in terms of the privacy you have even within your own home. Yeah.
You got a little bit of an ambiguity here too as well, because there's the expectation that of like what you deserve versus what is capable.
Yeah. So Ted, and then we were going to jump into the school
I may
context.
be getting a little ahead, and I'm thinking in the context of the school, particularly the public school. You may be covering this later. Now it's not unusual now they have school resource officers.
Yeah, we're going to talk about that a little bit because that's an interesting
Yeah,
context
and,
too.
So one of the things that is happening, that after school, they bring in the dogs to sniff the lockers. Now, that's a school situation now.
Mhm.
I don't know what the courts are saying about that. I know it's happening. But
Dog sniffs are, and this is another thing, they don't even consider a dog sniff a search. If they are on your property, if they bring a dog up to your front porch, it's a search because otherwise the dog wouldn't have been on your property. It's a trespass. But if for instance, if you're just walking down the street, they could sniff.
I'm talking about
In a school, they can bring the dogs down, and if they find someone's locker or car, they can search it. And they don't even consider it a search. It will be the basis for a search, but the sniff itself they don't consider a search because it's
then
just.
again, the school, of course, controls the locker, right?
And the school does control the locker. So let's see here. What do we have next? So I think we actually went through most of this. But let's think about now schools in this context. What's a student's expectation of privacy at school?
You know, this example came to me on the previous slide. One of the things, especially at the high school level, is parents might sign a do not photograph.
Mm-hmm.
Right? So if little Susie's in the math classroom, we can't take a picture of the yearbook. Okay, I get it. So what happens if little Susie goes to the football game and someone's taking a picture of a crowd shot? Click, click, click. Okay, we're at school grounds, granted, but it's a public
Not during the
event.
school day, but yeah.
And
That's a really tough question. I don't have a good answer to that actually.
it's one that's often debated.
Yeah.
Granted, students who have special ed designations for one reason would not be do not photograph. What do you do when they have a fundraising event? Sorry, I don't mean to pick on. Or they show up at the football game.
Yeah, I think that actually, and you think about it, that probably gets more towards the 14th Amendment right to privacy, in terms of being free of photographs you don't want to. But I don't know. I think that there is a difference between a school day when you're there when it's compulsory or essentially compulsory for you to be there, to be able to opt out of something, versus you voluntarily are at a football game or a fundraiser. But then you think about a school assembly or something during the day. That is a tough question.
Well, something inside the school.
Mm-hmm.
And I've got to go in, and I got check security, give me your driver's license, and all
Yeah.
that. Get it. Okay. But if I'm a photographer assigned to cover, the St. Charles East York football game, I'll walk in and shoot away.
Well,
I wonder what the actual
yeah.
language of the thing that the parents sign.
Photo room.
I think there would be
It
a.
might say on the proper school grounds, not at events or at large. It might actually have
And
exclusionary
So
language.
I think
what if the
short
event's
of.
on the school grounds?
I think
Well, I'm
short
just
of
saying,
you.
what if we look at the language?
I think short of you as a reporter signing on to something, they'd have a lot of trouble enforcing that too. I mean, it's one thing for the school authorities to take that picture and break the agreement.
They require the reporters to sign?
No, I don't know. Do they? I
Any
mean,
visitor assigned to the school.
no. I'm talking about the photos. Do they require you to sign anything about that you won't? So I think maybe the school's violated by not telling you, but that's attenuated enough. I think you'd have a lot of trouble with that case.
We had one case, student, the student or the single parent had an order of protection, okay? There's a case where my students were taking pictures, and it was actually the school police officer who came in and scared the snot out of my photographer. But there's a case where the school had it on file, but did not tell the classroom teacher. So, you know, I mean, we know eventually the school had it on file, but it puts the classroom teacher at risk, and if it becomes a legal issue, that classroom teacher could subject, you know.
Yeah, absolutely, absolutely. So what do you guys think? What is a student's expectation of privacy at school, and is it different than the expectation out of school? Do you have a different expectation for different reasonable expectation for your privacy in a school, inside the school versus outside of the school?
Are you talking about do you, or do you think that that students should?
Both. I mean, I guess I could ask you to predict what the law is, and I'll talk about it. Well, it's not necessarily clear what the law is, but do you think they should have a different expectation of privacy, or do you think that the level of what's reasonable is different in a school versus out of a school?
I mean, I'd like to know, I wish there were some high school students here to tell us, like, how
I
often
know.
are there searches, random searches at the school, or, we hear down in Grove South that sometimes they do bring the dog sniffing dog around.
Yeah.
It's really redundant. Yeah. And they bring the dog around to, sniff things, and it's like a random dog sniffing. So when I was in high school, I don't remember any of that stuff. I mean,
It's
the
gotten
only
more
time
intense. I mean,
they
even
searched was like if there was
Right.
evidence of a crime that happened, then they were like, okay, let's go investigate this, open your locker.
right.
So what's interesting, we've got thousands of school districts, and we have thousands of boards, and some are very conservative. And of course, their attorneys may take perfectly all right, but they're satisfying the school board that wants to have zero tolerance. So you had a lot of hypothetical situations.
Yeah, you do.
that are actually
Oh, yeah.
happening now. So a lot of these questions, except for what Stan mentioned, may just be hypothetical.
Yeah, absolutely.
Now, what situations aren't hypothetical? Now, I'll give you one instance. About 4 or 5 years ago, I was sitting in on the discussion in this very room, and a student's smartphone was confiscated. So the big question was, what rights did the parents have? And you were in there. Now, this was fairly new at that time. I don't know what it is now, whether you can confiscate.
Oh yeah. Well,
Oh, Lord.
I won't bury the lead. In certain situations, they definitely can. We'll get into some of sort of those, what those situations are for sure. So I'll try to move on then, so we can start getting to them. So searches in schools. We're first going to talk about suspicionless searches. So that is, a dog sniff isn't exactly a search, as I said. So what a lot of these are drug tests, random drug testing. What do you think? Can they force students to submit to random drug testing?
They do.
They do.
Well,
Yes, they
especially
do.
students who want to participate in
Extracurriculars,
activities.
yeah.
We actually have a community activist or two in Lake County at one of the school districts who were advocating for the student privacy of not having to undergo that kind of icky testing, just because they were participating in extracurricular and drawing the distinction between the other students and singling them out.
The extracurricular activities, I'm not sure if the Illinois High School Association has a policy in there. But if the ISSA is sanctioning a student activity, and they do everything from bass fishing to football, but you not, can they not say this is a requirement of the ISSA? I mean, they mandate
Through the schools, it's still the schools doing it. I mean, that does change the context a little bit, but and I know the cases are going forward right now, whether IHSA is subject to, for instance, Freedom of Information Act, Open Meetings Act, so, is it a public body for those? I think in this context, especially where they're talking about fundamental rights, they would probably consider that government intrusion, so I don't think it would change the context too much. But you're right, I mean, extracurricular activities, they've definitely been able to do it. And this first case here, Veronia School District 47J v. Acton, it was in 1995. And this one was actually pretty specific. This was one of the first cases on this. And what they had were 3 factors. They imposed it on student athletes for 3 reasons. They thought that they had a drug problem in the school. They thought that 1, student athletes were sort of leaders of the drug culture. They thought 2, student athletes should be role models for the student body, and 3, they thought there were additional health risks and safety risks for athletes who were on drugs. Well, the Supreme Court heard that, and I don't think it's any surprise that they upheld that. Now, I think it's interesting to look there at the situation where they had this drug problem already. The court brought up what's called the special needs doctrine, and that's there are sometimes exceptions to constitutional rights where the government can show a compelling interest. It's a high standard to meet, but they did bring it up here. I don't think the case would have gone that way. There were concurring opinions. I think they would have gotten there without the special needs doctrine. And later on, I think they shied away from it. But I do think it's important to note that they weren't, doing this on the basis of just you can do it for extracurriculars. They did sort of this balancing thing. They looked at there was an intrusion on privacy rights, but they had these 3 factors that were present, and thought it was reasonable for the school district under those circumstances to make students submit to that search. Yes?
Now, Supreme Court rules, they make some general rules regarding it. Quite often, when it gets down to another level, there isn't much guidance as to how it can be rule applied in different contexts.
Mm-hmm.
So I'm always often curious as what happens later when it gets down to the district courts and the appellate courts.
Yeah,
because
yeah.
It may change. And it may change in different
Yeah,
districts.
yeah, and especially when we get into the technology stuff, where they're going off of earlier kind of hard evidence cases from the Supreme Court and trying to apply it to technology. The district courts and appellate courts are all over the place. They're trying to apply these standards to brand new places. Judges, frankly, a lot of them aren't that familiar with technology, and they're still trying to apply those rules. So you're right. I mean, the Supreme Court has given some pretty broad standards on this stuff, and we do see differences across the country on a lot of the cases. So the second case, Board of Education v. Earls. This was 2002, and this was more expansive. The Board of Education in that case was applying the random tests not only to student athletes, but to all extracurricular activities. So you're talking like Scholastic Bowl type activities. So you get rid of that safety thing, all the stuff I said about student athletes, and moreover, they hadn't shown a particularized drug problem in this district. What do you think the Supreme Court said?
That it was okay.
Yes.
Say what?
That it was okay.
That it was okay. I believe it was a 5-4 decision, so it was pretty close. But the Supreme Court said it was okay, and they really they moved away a little bit from the balancing test, and they moved more towards, hey, this is an extracurricular activity. They aren't submitting everyone to it. But the courts are still sort of grappling with that, and how you how would it apply to a full school context rather than extracurriculars? Any thoughts on that with where we might stand on that? If York, if Elmhurst School District, so York is District 205, said, we've had drug problems, we're going to submit all our students to random drug testing, you think that would be upheld?
Based on what you said about Board of Education v. Earls, yeah.
Oh, all the students?
All the students, not just extracurriculars.
Oh.
That's all.
Well, it depends. What was the reasoning in those cases about the nexus of the extracurriculars and the athletic?
Yeah, I mean,
programs of
that's the whole
school?
thing is that they started to get away from that. I think that if you look at Veronio, when they were talking about the special needs doctrine, maybe you can get to a point where, say they had someone die of an overdose in the school, or a couple people, where it's really looking like it might be an epidemic. I don't know. Is that special needs doctrine where they could make every student submit to it?
I'd like to make one observation. I was in a school
Mm-hmm.
many years ago, and now I do attend school board meetings, and there doesn't a meeting go by when they're amending the school book manual covering a lot of different situations. I mean, the schools are more, except for the military, are more regulated than any other institution I know.
Yeah.
It's just amazing.
Yeah.
And almost every meeting, they've got the manual increases. And I ask quite often, why are you passing passing all these, and they said, well, you know, we're reacting to what we're told to do, and in the legislature, whatever, we're highly regulated, certainly in the schools, and even at the grammar school level, so what's the parent to do?
Yeah, and I think it's really interesting. There's something that just happened in Illinois where a student was at, it was one of the schools in the city that you have to apply for, but it was a public school, and she dyed her hair red. And they have a rule that says natural colors only. She's suspended. She's out of school right now. And I noticed a lot of people were commenting and saying, well, she knew the rules. Look, they talked about it. It was in the handbook. But if you've looked through these handbooks, I mean, it's a lot of rules. I don't know how you're supposed to keep track of all of them.
Well, I think it's ridiculous, quite frankly. If I were in the school, I'd be asking a lot of questions.
Yeah.
But the big question is, you pass a rule, maybe the attorney says, well, it's okay.
Yeah.
But it may be totally unreasonable.
Mm-hmm.
But they pass it in some districts. And then you get suspensions that affect
Yeah.
families.
Yeah.
Well,
Stan and Leon.
Let's go back to the random drug testing.
Yeah.
Say we do random drug testing, and student A realized he's got some kind of controlled substance in his body. If he's on medication for ADHD,
Yeah.
I believe that's one that's controlled substance.
Mhm.
Okay, he has a reason to have that in his body.
Mm-hmm.
Now, can the school reveal a student's medication history to authorities without parental permission?
Well, that's getting into FERPA territory, and we'll go over that later.
And maybe HIPAA territory.
Yeah, I mean, maybe that too. It's interesting when you get to medical records. There are limited situations, but that data is generally secure. I can't say it's fully secure because it's not. But generally, that's going to be pretty private, and really short of any even for teachers within the school district, they aren't supposed to be accessing that information without an educational interest in it. So really, they shouldn't be accessing that information. Yes.
I just want to make sure I understand these handbooks, because I'm coming from a higher education background, serve as the codes of conduct for students as well.
Well, so you have the school board code, which is just hundreds of pages long at all these places. But the student handbooks are hefty too. I remember the ones. I don't even know if they handed out to the. Yeah, I don't know if they even handed it out in high school. I remember having to sign it because I was a student athlete, and like you'd sign, but you weren't looking through all 50, 60 pages of that thing. Right. And even if you did, you weren't going to remember it. So.
And I'm looking at these codes of conduct for higher education. Mm-hmm. Thinking, like, you need a lawyer just to defend yourself.
Oh yeah, I know. It's crazy. And the fact of the matter is, you need a lawyer to defend yourself. But what's your solution? It's not exactly an expedited process. And if you get in trouble for any of this, even if you can defend yourself, and we'll get into this a little bit more later, we talked about it in the speech context, how Tinker v. Des Moines, it's 4 years between their speech and the Supreme Court decision. Well, a search case, they find something illegal that they weren't, they had an illegal search and find something illegal on you, you could be kicked out of school and you aren't going to get a remedy until you're way too old to be going to high school. So it's a big deal. So getting to this full student body, this is an 8th Circuit opinion from 2004, Doe ex rel. Doe v. Little Rock School District. And this one was for a full student body. I believe they had showed that there was a drug problem. The court struck this down, but on 2 grounds, so we don't know where to go with. One, the school was turning over the information to law enforcement. Once you're in that context and you got government actors doing that, you're essentially in a situation where you would need whatever law enforcement would normally need. And 2, they did talk about how it was applied to all students, and that they compared that to Veronia and Earls and invalidated on that. Would it have stood though if they weren't turned over to law enforcement? Sort of remains to be seen on that. Now we're going to get into suspicion-based searches, so individualized searches. The first one, and both of these are pretty famous cases. The first one is New Jersey v. TLO. TLO because this is a minor, we don't know the name. This situation started with 2 students, 2 female students were caught smoking in the girls' bathroom. I think TLO was 14 at the time, maybe 15. They were brought into the principal's office where TLO's friend admitted that she was smoking. TLO did not admit that she was smoking. principal asked to see her purse. He wanted to search it. She did not want to consent, but she was forced to consent to a search of her purse. The principal's search revealed a small amount of marijuana, rolling papers, a pipe, empty plastic bags, a large quantity of money and $5 bills, an index card that appeared to list students who owed TLO money, and 2 letters that implicated TLO in dealing marijuana. They called the police. She was expelled from the school, fined $1,000. I think there might have been more criminal penalty as well. What do you think? Was that search reasonable? Well, was it legal?
Compelling the interest of the government.
Need a court order, don't you?
I don't know. Let's hear other opinions and then I'll get to it.
Well, they searched her purse.
They searched her purse.
That's.
She had been, you know, teacher smelled cigarettes coming from the bathroom, came in there and she's there with her friend, you know. By the time you get to the Supreme Court, you don't necessarily have all the facts, but presumably caught close to red-handed. She wouldn't admit to smoking when she got to the principal's office, but they wanted to search her purse for evidence that she'd been smoking, for cigarettes, which aren't allowed in school, of course. Plus, she's a minor. She wasn't allowed to have cigarettes.
Nowadays, they reserve the right to serve your backpacks, but your purse, I don't know, like, how big was this purse? Was it like a backpack purse, or was it like
I think it was
a
just
little
a purse.
where someone might have some private items in there, and it's
Yeah.
almost considered an extension of your human body
Mhm.
because you keep it close to you?
I think it was just a purse. We can assume it was, I think.
And I would say that it was bad, that they should not have forced the search.
If it was a locker, that's a different thing. But if it's a purse, that's a personal.
Ted?
Are you giving us 5-4 decision, Tom?
No, this one was actually pretty heavily in favor of the school that they could search.
When he searched the purse, he didn't find evidence that she was smoking.
Well, yeah, you're right. But here's the thing. For
That's
any
the issue,
search,
isn't it?
if a search is legal and they find evidence of another crime, tough luck.
Yeah.
You know, if they're searching my house because they think I'm dealing drugs and they find illegal guns instead, I'm out of luck as long as that search was legal. So, no, the court said that this search was okay. And they look for 2 factors. And this applies to all searches. They look for, was the search justified at its inception, and was it permissible in its scope? In this case, they were justified. They were finding evidence that she broke the rules and actually committed a crime by smoking underage in a school that didn't allow smoking. And it was reasonable in scope, they said, because she could have cigarettes in her purse. They weren't digging through, there was an interesting case that we had to do, like a hypothetical in law school, where they were looking for a weapon and looked in someone's eyeglasses case within their backpack and found drugs. That's a tough call. You know, could you find a knife in there or something? I don't know. But this is, you know, they looked in her purse and immediately saw these drugs. They weren't, you know, digging through things. So what the court said was that they're balancing between the individual's, even in a child's, legitimate expectation of privacy and the school's interest in maintaining order and discipline. It's a little bit different than the context outside the school. I think that, and you know, you start getting into the weeds a little bit here, but what they said was, is it reasonable giving a totality of the circumstances? So this entire situation of what they had observed with the student, what they know about how students behave, and what their interests as a school were.
Now, I focusing on the person that decided that a search should be made. You did the principal?
It was the principal in this case, yeah.
And how much authority does the principal have?
You know, from the constitutional perspective, obviously they might be breaking school district, code. Maybe it's the superintendent that should be deciding that. And if a teacher decides, it's a completely different context. I assume a lot of schools are going to write in that teachers shouldn't be conducting searches. The principal might have the authority. The thing is, from the constitutional perspective, even if that's written in there and the teacher does it, doesn't really matter for the constitutional question. So what we're looking at here really is that the teachers were allowed to go in there with reasonable suspicion. In the context outside the school, if the police are doing this, they need probable cause. Reasonable suspicion is a lower standard. But that's what the court has essentially negotiated with themselves in the interest of the school here, in the interest to maintain a positive learning environment. Let's move on to Safford Unified School District v. Reading, 2009. This one, a student was caught with prescription ibuprofen pills. The facts are really, really convoluted in this to the point where the court couldn't even sort it out. But essentially what happened is the student who was caught with a prescription ibuprofen, I think it was naproxen, said that another student, I guess it would be Reading, was selling these pills. So they brought her into the office. She denied having or selling any of these prescription ibuprofen pills. They initially searched her backpack and her outer clothing, just a pat-down search. They didn't find anything. The male principal sent her into the female nurse's office, where they made her take off her outer clothing, made her pull at the strap on her underwear and her bra to see if there was anything there. They did not find anything. Shouldn't matter if they had, but as you know, I think we can suspect when they find drugs on people, they do treat them differently often through the court system. Well, what do you think? Is that a reasonable, under what we heard from New Jersey v. TLO, do you think they could do this? Why not?
Because now they're, like, suspicion is probably going through her locker,
Backpack
stuff.
So that's the justified at inception, right?
But
they were
like patting down somebody
Yeah.
and getting physical like that, that seems a little, especially to a minor.
What do you think about the fact that it was just on this tip from another student and not that they had, in TLO they kind of knew she was smoking?
Right.
Does that matter, that it was just a tip from another student? We don't get too much indication. I think the court was, they did point out that this probably would have been justified at its inception, but because they weren't focusing on that aspect, I'm not sure we can rely on it too much. And the lower courts have had to grapple with that. Student tips, I mean, that's tough, right? Is a student tip enough to justify, things like that? So,
Well, even when, I'm sorry, Ted.
yeah, go ahead.
What's the process for determining whether in fact it is an illegal drug?
That would be in this case it was a prescription that she wouldn't have had a prescription for, so that's going to be, I don't know how they schedule naproxen,
So
but
the teacher's got a list of.
that's a great question. No, I'm not sure. I mean, I think they probably just knew offhand that it wasn't. And not to mention, students in school, a lot of schools control even if you do have ibuprofen or Tylenol, and especially if you go and sell those to another student, that's going to be against the school rules.
Yeah, oftentimes,
Even
you
if it's
have to,
Tylenol.
like, the nurse has to keep the
Yeah.
pills for you,
Yeah.
and if you want to take it, you have to go
Yeah.
to the nurse's office to
Yeah.
take the pills.
I-
So to find it on a
Yeah.
student, I mean, I don't know in 2009, maybe I don't know if that was the rule, but to find pills on a student
who
is
decides-
bad because it's against their policy, regardless of if they have a prescription or not.
How did the court rule in the case, the Reading case?
In Reading, they ruled against the school in this one. They said, and it's exactly what you said. It was reasonable it was justified at its inception, but it was not permissible in its scope. They could look in the backpack. They could even pat her down, but to have her have to take off her clothes, it's that next intrusion. Now, let me just very quickly, and I sort of I actually spoke sort of favorably of Justice Thomas 2 weeks ago, who, full disclosure, is not necessarily one of my favorite justices. Well, I'm not going to be so nice to him this time. Let's hear what he had to say on this one. He was the only dissent. He he said that the school had a reasonable suspicion that Reading was in possession of drugs in violation of these policies. He concluded that it justified a search extending to any area where small pills could be concealed. He warned that the majority's decision could backfire. He said Reading would not have been the first person to conceal pills in her undergarments, nor will she be the last after today's decision, which announces the safest place to secrete contraband in school. Over prescription ibuprofen, he thought she should be strip-searched. Anyone agree with that? Now here's the question though, because Justice Breyer, I think, wrote a concurring opinion, and he pointed out that this was over ibuprofen. What if it was over heroin? And what if it weren't just a student tip? What if what if they had a text message from her talking about it? Or what if it were a teacher tip? I don't know. Do you think they can search a student then if they think she has heroin on her?
The school shouldn't. They should have.
Well, I'd agree
parents
with that. I'd agree with that as a matter of policy, that you'd probably want to get the police involved. But a couple things. One, with any crime, you're worried about evidence walking away. And once you call the police, there is a different standard. If you're, well, essentially, if the police are called in, you're usually going to be talking about probable cause rather than reasonable suspicion. There are exceptions to that with student resource officers particularly. But, you know, I think it does, again, land us a little bit in this gray area considering what they think the offense was. You know, you can think of situations where maybe they would be justified in strip searching a student. And I'm playing devil's advocate a little bit, but, you know, if you think they have a dangerous weapon on them, if a student's suicidal and you think they have a dangerous weapon on them, maybe that's justified. I don't know for sure, and the courts are going to have to grapple with that because, well, there's a lot of room left by the Supreme Court.
So are you saying that these cases are so fact-specific that the fact that we're talking about prescription ibuprofen versus another kind of drug is like something that, you know, these cases could turn on that dime?
I think this one in particular, the court was very, other than Justice Thomas, was very much against the strip search. But, you know, you can think of things somewhat short of that where they wouldn't have been justified, and it is going to turn on the facts. And the fact that Breyer brought it up again, I think it was in a concurrence, well, they're kind of calling that in, aren't they? I mean, that you are going to have fact-specific inquiries. And they talked about it previously in TLO about a totality of the circumstances. Totality of circumstances tests are always fact-specific. And, you know, in terms of searches outside of the school, we have a lot of case law on that, both in the district and appellate level, as well as at the Supreme Court. There isn't that much case law at the Supreme Court level, so we're always going to be grappling with where.
Inside the school.
Mm-hmm. Leon, did you have something?
Not strikingly relevant, but the suicide thing just kind of like.
Yeah.
I think that the state passed last year a law for universities, not for high schools, that allowed for pre-authorization release of psychiatric information if somebody suspects a student to be a risk to themselves.
Yeah, and FERPA actually allows it in certain health and safety release of student information, and there's question whether health records are student records under FERPA. Gets really interesting with that. I mean, but
you know, the mental health records confidentiality act, I forget the exact name of it, but it doesn't actually cover offices for providing accommodations for students with disabilities. So
yeah.
all the information that you hand off to the whatever office it is, that can get passed on to whatever official.
Yeah.
Even though they say that they're confidential, they're not confidential by law.
Yeah, and we'll get into that more in a second. I also I think this is the Breyer quote I have here. What he questioned was that what he said rather is that you needed a reasonable suspicion of danger or a resort to underwear for hiding evidence of wrongdoing before a search can reasonably make the quantum leap from outer clothes and backpacks to exposure of intimate parts. So according to him, there are situations where a school would be able to do that. You know, again, we're getting fact specific, but I do think that's important to look at how the Supreme Court's trying to balance different interests here. Ted.
You're using the term without really defining it in terms of context. Reasonable search or reasonable suspicion.
Well, reasonable suspicion, yeah. I mean, you know, would a reasonable person have suspicion that a crime was committed, or in the school context that a rule was broken? You know, defining it beyond that, again, you're getting fact specific. You're talking about. I think it's great to talk about it in terms of police actually. For instance, when they stop someone on the street, it's totality of the circumstances, and they bring things into it like that police officer's experience, like the neighborhood you're in. Like whether that neighborhood's prone to crime, what time of day it is, all these different things.
They actually have reasonable suspicion. They can use reasonable suspicion.
Yeah.
No, I understand that, but in the context of the school.
Well, Terry stops though.
Student acts some way that gives the teacher reasonable suspicion that they don't want their bag open or whatever.
Yeah, I mean, it's just fact specific. You know, it depends on the teacher's experience, and I think that's part of the problem here, both for schools and for students, because it is a little bit of a gray area, and you don't know what reasonable suspicion is. So it's tough to define your privacy rights.
All we know is it's lesser threshold than probable cause.
We know that, yeah, and then we look at the cases and we see, they've gone back and forth on them, and at the Supreme Court level there isn't that much, and I do include in all these discussions a little bit of appellate and district court level stuff, but we're trying to come up with where the law stands right now, and appellate and district court doesn't mean the law is gonna sit there very long. Especially, I'm trying to hit areas where there's a split, because that's isn't that fun? So I think we talked a lot about the open questions about where they strike this balance. A couple things. Student resource officers, I think a couple people have brought up now. These are police officers who work in the school. The courts have generally held that if they are at the direction of the school, then you're going to go to the standard they set out in New Jersey v. TLO. If the police officers are acting on their own outside of the direction of the school, it's going to be your full Fourth Amendment protection, and that's looking at cases like CATS, where it was the actual police acting, not the school. So that's an important distinction, because we've talked about schools, reasonable suspicion, and the scope of the searches under that. A lot of these searches that the school is doing, if it were a police officer doing it, they would need to go and get a warrant. And qualified immunity I want to touch on really quickly, especially because Justice Sotomayor just absolutely hammered police departments over this issue. What qualified immunity is when you have these situations where you have an illegal search, the actual government actors, whether it's police or school administrators, they can be held liable in terms of monetary damages or even possibly criminal damages if they broke the law. Qualified immunity is if you have a situation where the law wasn't very clear, then those people are immune from the individual issues there. And essentially, I've seen it called unqualified immunity at this point. It's very hard, short of having a case where it's just so cut and dry that everyone knows it. They have really let government actors off the hook on this. Yeah.
Don't they even have like a requirement that they have to show that they were acting in good faith?
Yeah, I mean, I don't want to get too much into good faith, but it's very difficult. You're getting into people's feelings, and their thoughts in partaking in an action. And you're talking sophisticated people too, especially in the police context.
So you're saying that that because the law is unsettled, that the government actors are not found liable because the law is...
In Safford v. Redding, they found that the principal and the nurse had qualified immunity. They strip searched a student and they said qualified immunity, the law wasn't settled. To me, I mean, and this is my personal feeling, that's extreme. There were, I think it was Stevens joined by, I forget if it was Ginsburg, concurred in part and dissented in part. They said that they shouldn't have gotten qualified immunity. But generally, the Supreme Court's been very, very favorable to government actors on that.
Any kind of liability under like tort law.
Individual, yep. All right, let's go on to technology. So this is a great quote by Chief Justice Earl Warren. It dates back to a case in the 1960s. The fantastic advances in the field of electronic communication constitute a greater danger to the privacy of the individual. We've already talked about this a lot in terms of surveillance, post 9/11, Patriot Act, all that. I mean, and here he is 40 years before talking about that. And, in light of the cases that we've seen, how should the government, and particularly school authorities, treat information stored on a computer or a phone? Can school authorities search your phone, a student's phone or a student's computer? And for the moment, we're going to go as students owning the phone or computer. I know schools sometimes issue computers, so just going away for that right now. Are there situations where a school can search a student's phone?
If they have reasonable suspicion.
I'd agree. What can they do to search the phone? I mean, can we think of any examples where they might be able to? Let's look at it a little bit. And of course, reasonable suspicion, and then it's got to be permissible in scope. So this gets tough. If you know a student took a picture of another student in the bathroom, it's clearly breaking a school rule, breaking a law too, probably. You'd probably have reasonable suspicion to look in their pictures on their phone, right? What about their text messages, emails? No? Leon?
Or it doesn't actually have to be the owner of the phone to be suspicious of a crime, just that they have evidence, because they could be, say, videoing.
Yeah, well, that gets interesting, like where they have evidence of another student committing a crime or breaking a rule. They wouldn't be able to look into it in that case without either permission, or you'd probably have to take it to law enforcement and get a warrant at that point. That's you think about it like evidence of a crime in your home or something. They can't just the warrant then has to be for your home. It can't be that they're looking for evidence of this guy's crime.
So maybe it's not a crime, but just violates the school code.
Mm-hmm.
They have reasonable suspicion that there's evidence on the phone. Could they then ask the student for their password?
I think the only way they could maybe do that, and this is getting a little bit complicated, if the student broke the rules by videotaping in the first place, or maybe if they were passing around the video of the crime, then they might be able to get in there. And you started to ask about passwords. I know we talk about this every year at Downers Grove. My impression, and I think the courts have generally sided with students on this, you can't force them to give you a password. But again, if they committed a crime, well, you can confiscate their phone, hand it off to the police, and the police are going to get a warrant. There's one more quote I wanted to touch on here. This was actually very recently. It was Justice Alito. And this is getting back to where we were talking about what's your reasonable expectation of privacy in a technology sense. He said, in determining whether the examination of information on a cell phone constitutes a search, what do you think we are doing? Are we answering an empirical question? What is the reasonable expectation of privacy of a person in 2014 who has a cell phone on his or her person? Or are we legislating what we think is a good privacy rule? So again, what's the expectation of privacy with a cell phone, whether in school or out of school? And student computers, I think it's a good one too, because we were talking with our interns from York High School today, and they actually, a lot of them purchase their Chromebooks from the school and they get a discount, but the school has a monitoring tool on it. It's supposed to only be on during the day, but is it on at night?
When you say purchase, you mean
they own it.
Own it for that year, or own it outright?
No, they own it.
They own it. They get money back at the end of their
it.
senior year. If they give it back to the school will give them money back.
It's like selling it, but they basically own it, but they have no privacy on it whatsoever.
During the day, allegedly only during the day.
But
Well,
I've heard from students saying they've noticed the monitoring software on at
Yeah,
night.
they've
Oh,
mentioned
really?
that, yeah.
Does this Chromebook have
It's
a
creepy.
CD, or
I
does
don't
it
know.
have a USB port, anything that you can interact with, or is it just sort of like a tablet? where-
No, it has all the
Okay,
stuff you can interact
Because
with.
if somebody's technically savvy enough, then they can just like reformat the.
don't
They
expect
monitor,
high
like
school
if the software is not working, it knows and it tells them, and I think it's just really interesting
What are
to.
they gonna do? Give us our Chromebook back? I bought it.
No, my question was, after you graduate,
probably sign a waiver.
do they turn off the monitoring?
I asked them that today, and they weren't too sure. So that was very.
That's why they tend to give it back.
That's why you should give it back.
So
Monitoring software will work outside the school. Could it be?
Well, I think
Yeah,
it
it
does.
does.
It works at your
It
house.
does.
Yeah.
Like, you don't have to be on Wi-Fi or anything.
Yeah.
It still moderates you.
I think that's
Oh.
where it would be reasonable, if it was using the school's Wi-Fi only.
But like,
And schools can search your locker. What if the school owns the computer, but you take it home with you? It's
That's a
complicated.
different story.
Yeah, and I mean the courts have had trouble grappling with this. I mean it's all over the place on these cases. And just to move forward here, so I brought up some cases for technology, CATs, which we went over with the thing on the outside of a phone booth. It's interesting. I mean that was something when they decided the case in 1967, I think it was, relatively new technology, something the court had to grapple with. 2012, we had United States v. Jones. They had a warrant to put a GPS device for a limited time, limited scope on a person's vehicle. They exceeded the scope of that warrant. So then the question was, without a warrant, can you put a GPS device on someone's car and track them? What do you think?
I would say no.
You'd say no? Okay.
Without a warrant? No.
Without a warrant? Why?
What's the reason for it if you don't have a warrant? What grounds do you have?
Well, here's the thing. You can follow them around, can't you? You can put a tail on
But
them.
that's in public, but now you're putting electronic device
On the outside of their car.
What happens if they go into
They didn't go into the car. They put it like, under the bumper or something.
What if it's parked on the street? And
Yeah, it was parked on public when they put it on.
I know, but that's still a personal vehicle, and you can't do that.
You put a camera on a car when nobody's. It's a surveillance device just because you can follow them.
Well, surveillance. I mean, what if you have a helicopter up high following them around? Can you do that without a warrant?
I think that's actually already being bought right now.
Might be.
That,
But
you know,
how about, I mean,
very-
well, tailing them in another car where you're 2 blocks back and they can't see you. You can follow them forever, right?
Right. But you gotta put in effort to do that.
You do have to put in an effort. Well, so this is actually, it was 2012, so I was in law school, and we talked about it a lot because everyone was really split on this one, and I believe the court was very split. They said it wasn't okay. They said they actually went down on this, and this is where it's going to get really interesting with future cases. They said it was a trespass to chattels, chattels being property. They said that putting the GPS device on there was a trespass on the vehicle, which made it an illegal search. So we're not even, in terms of trespass, a trespass is always gonna violate a reasonable expectation of privacy, I guess. So it's an interesting context, and sure enough, the most recent case of interest on this, I think it was an appellate court, said that swabbing a car for DNA was a trespass as well, which is pretty interesting. Now, someone, I don't know, gets their DNA on the door handle sometimes, someone walks by and swabs it. That's also a trespass. So it's going to be interesting to see how that plays out with the trespass context. It's a little bit of a tough, another tough standard to deal with.
Just an observation, we're talking about these cases very abstractly, in most cases hypothetically. But what is happening actually in these school districts is that legal fees are going up tremendously.
They are, yeah.
Mainly because of these student cases.
Yeah.
One school district is spending $360 per
Yeah.
student for legal fees.
Yeah. And that's the whole problem, though, isn't it? Without any direction on these things, without solid lines, schools on the one hand, they want to have a safe learning environment, and they want to push the rules to do that. They want to be able to monitor cell phones if they think crimes are going on. And they have some responsibility to do that, and parents and the school board might be pushing them to do that. But on the other hand, if they screw up, they're going to go through a lot of litigation. It's going to be very expensive.
Well, in some school districts, this gets very sensitive, and between
Yeah.
parents and here's one problem I see. Now, we're talking about the teacher or the principal
Mm-hmm.
decides to make a search. Do they go through any workshop to be able to make a decision like that? Do they? I don't know.
They should be. I mean, the thing with a lot of the cases, again, they might not be going through school policy. I think a lot of the administrators especially learn about this in continuing education courses. And they do hear about it, in workshops with the school board or with the school lawyer. Teachers, from my understanding, I don't know district by district, but teachers are often told not to search. They're told not to search. They can confiscate a student's cell phone, but you're bringing it to the principal, and the principal's deciding what to do with it. If the teacher violates that school policy, well, they violated a school policy, but that doesn't reflect on the constitutional issue.
One of the problems, when I've been in a school situation, and I go to school board
Mhm.
meetings, I talk to teachers, this is a stressful situation.
It is,
For the
yeah.
teacher, the student,
Yeah.
the community, if it's really gets a lot of notoriety. So this cannot just be talked about just abstractly. I mean, you see headlines about this
Mm-hmm.
stuff. So where's the guidance coming?
It's not. I mean, that's the point. It's
Let
not.
me tell you, the lawyers are getting whacked because
Yeah.
they have a suspension hearing, they show up for 4 meetings and bill
I mean,
$600.
you're always going to try to follow what the courts have said in your jurisdiction, but that doesn't mean it's all over the place right now, and a lot of it isn't really hasn't been litigated out either. I mean, you got the cell phone in one context, but not in another.
Well, what do you get in a situation, racial discrimination,
Mhm.
where you look at the cases and who's getting searched and
Yeah.
whatever?
Well, we're going to talk about that a lot in 2 weeks. In 2 weeks, I'm going to talk a lot about the discrimination protections, and not that they cover everything, because you're right. I mean, a lot of this does depend on who you are and what district you're in, and that's a really, really. I don't have any good answers for it, because you're right. It is different depending where you are and who you are. So we're going to look at FERPA. FERPA has 2 main functions. One, provides parents of minors and adult students access to educational records and to appeal errors. So you actually...
Thank you for putting that first.
Well, yeah, and it's interesting because you often hear about FERPA in the privacy context, but it also gives rights to parents and students, that you can look at your records and know what's in there. That's important, right? Because there are situations where they can share your records, and if you don't know what's in there, wow.
Yeah, when you say rights, it's in quotation.
I know.
It's not, it's actually just an obligation for funding. It says that if schools
Yes,
are to
that's
receive
a
this
good
money,
point.
that you can violate this as much as you want if you're not receiving
Yeah.
federal money. And if you show a habit of doing
Yeah.
it, then they take away your money.
And in a
But
slide or two, I'm going to get into that. There is
so
no,
when you file
yeah.
a suit, the courts are like, well,
No, there's no cause of action under FERPA. There's no individual cause of action. And so you're completely reliant on the Department of Education enforcing this.
yeah, which
That's
they
really
typically
tough.
steamroll students.
Yeah, and I mean, in extreme cases, sure, they could pull funding. The Department of Education is very hesitant to do something that extreme. I mean, you even, and again, we'll get into this in 2 weeks with the transgender bathroom issues and discrimination cases. It's such a harsh punishment, not only on the school district, which, sure, they'll pay through elections and everything, but it's so hard on the students when that happens and the community.
How do they classify educational records?
We'll get to that too, because that's interesting, and it's also not all that cut and dry. Again, because we're talking about a law that is governed and enforced almost entirely by the Department of Education. That makes it tough. You don't have those individualized litigations that define it out even as much as, for instance, on searches. So the second part limits how educational records may be shared or released. I say limits because there are situations where you can release them. So what is an educational record? What do you guys think? What's an educational record? Leon?
Oh.
Putting you on the spot.
Pretty much almost anything except for like handwritten notes that are intended to be temporary memory aids, and also medical records.
Temporary notes,
Medical
does that
records I've seen,
include
yeah.
email correspondence about a student?
That could be.
Could be.
Well, when you submit a FOIA request, it's typically denial by FERPA. If there's significant student information in them, they're considered student records, and they'll say like, oh, well, this is exempt because it falls under some sort of restriction. What's the catch-all that it says like in FOIA if it violates some other law?
Yeah,
They point
yeah,
to
some other
FERPA
law.
as the law.
Sam?
What's not up there, unless there's another slide, are standardized testing results. Now, the administrators, well, you can't release that, it's FERPA. But if little Mary Sunshine takes the ACT and she
Yeah.
gets a 36, it's all over the building,
Yeah,
okay?
Yeah.
Now,
Little Mary Sunshine.
I don't know
it's a good point.
if there's if they sign a waiver saying, I'm taking this test and you can use my results, and I don't know who releases them, because the tests are administered, the ACT, by the college board. And, you know, as soon as you take an ACT test, once you get the results,
Yeah.
you start getting
Yeah.
letters, kids start getting contacted by schools that students didn't even know existed.
Well, for those actually, so when you take a standardized test, you actually, there's a release on it whether you want your scores released to schools or not, to colleges. So that's where that comes from. But in terms of the school knowing it, yeah, that leaks out, and that probably is a violation of FERPA, but it's not going to get enforced. Yeah, letters of recommendation. What do you think about that, or references? Those are, you know, in the file. The school, maybe a teacher wrote it to a college. Is that an educational record? Leon.
Yes, but you can also waive your
Oh.
right to it.
Yes, that's right.
It's not, unless, and this will cover it usually. It has to have educational information in it. So, say the teacher is your, you know, is an advisor for something or a group or something. It might not have educational information on it. So they actually look what's in there. So it actually has to be related back to essentially other educational records or information. Otherwise, not an educational record under FERPA. Health records we covered a little bit. There has been some back and forth on that, and it's tough. And there are other protections for health records in some cases, but you know, there's I would say there is a chance there of schools releasing health records. Immigration status. How about that? I can go to the next slide and I'll get us a little closer to that. Peer evaluations, I just want to cover, so like students grading other students. That's not covered unless it becomes an actual record, like if they actually grade something based off of that.
Well, I know is immigration status, isn't that protected through another line of Supreme Court cases?
I don't know, and would depend on the context, I guess.
Doe v. Pyler or something like that?
I'm not sure.
I mean, like the current conversation about immigration in schools, public schools.
I'm not sure.
I'm not sure.
No, but in this context, well, so here's the thing. So 3 categories of educational records. You have educational information, which we sort of talked about, or categories under FERPA, I should say. Personally identifiable information. That could be social security number, it could be DNA, it could be fingerprints, those sort of things. Then there's directory information, name, address, phone number. The only one of these that they can really release, usually, generally, is directory information. And the thing with directory information is that they have to give you notice that they're going to do it, and they have to give you an opt-out. Now, that's not necessarily, especially when we're talking about something like undocumented students. Well, they're not releasing your undocumented information. That's going to fall under personally identifiable information. But maybe there's a suspicion. Maybe they know your parents undocumented and someone wants to report them for whatever reason. All of a sudden they got your address. And, well, if you're an undocumented immigrant, maybe you don't speak the language that well. Is that notice enough to tell you what's going to happen with your information?
Are they putting up any rules as to when this information is to be destroyed? Because if it's in the school record forever or a long time.
At least the university has,
Yeah.
what the heck are they called? Record archives.
Yeah. That's not under FERPA.
Schedule. Or
Yeah.
something. So that, yeah, it's not under.
It's not under FERPA.
But I would imagine that public
Yeah.
schools, K through 12 have a schedule as well as to like when
Yeah.
records are destroyed.
I imagine that falls under the general laws in Illinois in terms of public records as well. But yeah, under FERPA, there's not anything with that. But that's a good point because you don't want these documents necessarily sitting there. You don't want your permanent record sitting there 10 years later and something. Yeah. So but that is a great question.
And I wanted to ask Ben about special education students because they came with a long trail of documentation for IEPs or 504 plans, which is not exactly a health record. Where does that fall?
I'd say that probably falls under educational information, but again, it isn't all that well defined, and the problem, once again, is that you don't have an individual right of action under this. So you would be, if you have or what you perceive as a violation, you'd be reporting it to the Department of Education. They would have to run an investigation, and then they can write essentially a reprimand, or the extreme case, they can pull funds. Let's go on. Let's see here. This just talks about no private cause of action.
Well, there's one step that you can do, which is the access provision, which is that if you dispute
That's true.
have the right, well, again, in quotations, you have the right to call for a hearing to amend or delete the record.
That's true.
Interestingly enough, FERPA says only amend, but if you go into a step further and look into the U.S. code, it does say delete.
Mm-hmm. I also want to point out state laws may provide some additional rights, including a private right to action, but they are not in any way required to do so. So it depends on your state. So there are some exceptions to FERPA, to the non-release of information. And I listed a few of them here, but just to go through them. They can release information to school officials with a legitimate educational interest. I would say an ACT score and spreading it around is not a legitimate educational interest. Often they talk about a teacher's curious about a student's IQ score or something like that. Yeah, so probably not. 2, they can release it to other schools to which a student seeks or intends to enroll. 3, to education officials for audit and evaluation purposes. That one gets a little bit interesting, right, when they're talking about auditing, because that other group probably should be keeping that information safe, and the school doesn't have an obligation to make sure they do. But that can be pretty broad for an audit or evaluation. To accrediting organizations, similar situation. To parties in connection with financial aid to a student. To organizations conducting certain studies for or on behalf of the school. To comply with a judicial order or lawfully issued subpoena. And in the case of health and safety emergencies. And finally, to state and local authorities within a juvenile system. Now, an interesting one that sort of, it falls under a couple of those in there in terms of organizations conducting certain studies for or on behalf of the school. Well, contractors and consultants performing services for the school can get that information as of, I think it was the 2008 amendments to this. Now, the school does have an obligation to try and ensure that third parties don't release the information. But man, contractors and consultants, and your only sort of thing to hang on to there is that the school is supposed to then keep it private. Leon.
I don't know if this is an exception. I think that this is a gray area, but information regarding graduate assistance for teaching assistants.
Man, I don't know. I know you've had to deal with that a little bit. I mean, I have gone over. So I think it would depend if you're enrolled in classes. If you're enrolled in classes and you're a student, and then it's a question of is it an educational record. There are some educational
aspects to serving as
an assistant. You would have to be enrolled in classes as a student because, for instance, if you're auditing courses, they don't consider you a student. Mm-hmm. And that's been litigated.
Probably would be eligible for a teaching assistant.
And then presumably in the contracts with contractors or consultants, the school puts in provisions stating that, you have to keep this confidential.
Yeah, they probably do.
And
then they got to
the
actually
school could
enforce.
always sue over breach of contract.
But depending on the situation, I mean, what situation is the school actually going to do that, especially when they'd essentially have to get to a point where they're worried that the Department of Education is going to pull funding. Otherwise, they're not going to spend the money to enforce that contract provision, right? Because there's no individualized cause of action. Now, depending on state law, they might. But
have you looked at the Illinois Individual Rights and Privacy Act or something like that? Students' Rights and Privacy Act?
I looked into it. I did not want to get into it too much for this. Stan.
A couple of things. First of all, what defines a contractor? Say, if the high school is administering advanced placement tests, they don't do those. I mean, the students take the test, they play dearly for them, and they're farmed out to be scored. So that's one question. The other question, which kind of dovetails into it, if you have a multi-school district, say 211, 214, those are the two largest high schools in the state. If the district approves the contract, does it have to be the same for all schools?
I wouldn't think so, but I'm not sure. And I think that is a major outstanding question in terms of who exactly qualifies as a contractor or consultant under this. They look to the work that they're performing, whether it's educational work. So I suppose if you had outside tutors, consultants, maybe if it's a program like where they're teaching students outside of the classroom, those types of situations. But I think there is a major outstanding question in terms of who exactly qualifies for that.
And wouldn't the school and or district have fiduciary responsibility to inform, if not the students, the parent or legal guardian, that this contract is providing this service and agreements?
You would think so. I don't believe that's actually required under the law, though. Leon. Oh, okay.
Sorry for confusing you.
I think that's all I got on FERB. Actually, let's see. That might be the last. Yeah, that is the last slide. So any other